The last time I filed with the Attorney Registration and Disciplinary Commission and the Judicial Inquiry Board in the state of Illinois, I always start out different. Sometimes I start out like when the Judicial Inquiry Board, I cited the judge for judicial misconduct, for failure to report the prosecutor for prosecutorial misconduct, and this is what I would use. All right, prosecutorial misconduct is when a prosecutor violates the law or code of ethics while prosecuting a case. It can include withholding evidence. Prosecutors may withhold evidence that could help the prosecutors may withhold evidence that could help the defense, such as exculpatory evidence, or that could lead to exoneration. This is known as a Brady violation, and that's what I always say. This is beyond a Brady violation, denying somebody due process, a fair trial, effective assistance of counsel, failure to abide by the rules of professional conduct and the code of judicial conduct. Is not only ineffective assistance of counsel, it proves the ineffective assistance of the court. And I would continue. Making improper arguments. Prosecutors may make improper arguments at our trial that overstep the bounds and propriety of fairness. Vouching for witnesses. Prosecutors may wrongfully vouch for witnesses. Discriminating. Prosecutors may discriminate based on skin color when picking a jury. Expressing personal opinions. Prosecutors may express their personal opinions about a matter in a trial. See, all this is forbidden. Prosecutorial misconduct can taint the credibility of the criminal justice system and lead to convictions. Civil lawsuits can be brought against prosecutors who engage in misconduct under 42 U.S. 1983. Okay, so there's a lot to be said about prosecutorial misconduct, and people used to think I was crazy when I would talk about this before the internet. I just remember a lot of things I read. I like to read, and I found the rules of professional conduct the first time in 1979. The 1979 revision clearly stated in the top paragraph or the top two paragraphs about this ineffective assistance of counsel is violating anything that follows. So they have to do everything that's written in the rules of professional conduct, and nobody does that. And any violations of the rules of professional conduct is a violation of the codes of judicial conduct, because it's mandatory to report misconduct in either or the rules and codes of judicial conduct. But nobody does that. The judges are supposed to report the state's attorney, the public defender. In a criminal case, in a civil case, there's fairness to the opposing party and the ineffective assistance. If your lawyer has not spoken to you and explained to you, have you read. And remember, a lot of them like to tell you what you read doesn't mean what you think it does. So refer to the letter of the law, which is a clear mandate in interpreting the law, that what has been done, what has been written, has to be done word for word to the letter. That's a mandate in interpreting the law. So I've never let anybody go beyond that. Anything devoid the letter of the law is disinformation, and that's illegal. Okay. I do a page on Facebook, Legal Reform. I'm old, as you can tell. Since I first read the Rules of Professional Conduct, Code of Judicial Conduct, I put a lot of things together, and it comes to the simple conclusion that due process does not exist. Due process does not exist if effective assistance of counsel does not exist. And effective assistance of counsel is mandatory by every attorney and judge. Those are legal obligations of all lawyers and judges, and that those legal obligations are written in the rules of professional conduct and the code of judicial conduct. You can't violate one without violating the other, just like in the Constitution. You can't violate one of your constitutional rights. They can't violate one of your constitutional rights without violating another. Ineffective assistance of counsel is existent. That's all there is out there. Okay, so if there's no such thing as effective assistance of counsel guaranteed to you in the Sixth Amendment, and you'll see it in my other videos, then you never had a fair trial. Due process doesn't exist. So whatever you're going through right now, look at it like this. If what they did in the beginning was illegal, what they're doing is now is null and void, is just as illegal. That's nothing but legal harassment. But if you read the rules of professional conduct, you would know that. Start with the ABA rules of professional conduct, American Bar Association. They have the model rules of professional conduct, which is a mandate for every state to use. That is the model that they can build upon. They cannot take away from it, but they have. Some states have. And the one I found missing the most is Rule 3.8, Special Rules of the Prosecutor, and it says, clearly states in there, if given exculpatory evidence, it's their job to exonerate that person. It's their job. That's why I think the Supreme Court got so pissed off when that got to them. You know, it's the job of every attorney, state's attorney in the United States. And so far, Illinois is the only one who's doing it. And I ain't bragging. I'm from Illinois. I ain't bragging. I'm pissed. You know.